ducky and her ducklings always seeking justice and truth. This ducky won't be silenced by the haters, seeking out the facts while providing the receipts. She is loud with her opinions in this cruel world of villains. This ducky will talk, give her sass, while still keeping her class. So join in the pond with the ducklings from all over the place.
All right, welcome back to the Loud Little Ducky. We are doing part 2. I know that Echoes is live going over stuff right now as well, which is fine. Welcome, replay crew. It is good to see you. All right. So I am putting Rob's fundraiser into the chat, and I will pin it at the top of this one as well. It is also in the description box below. And let me pin this to the top of the chat. There we go. All right. So, a comment that was said at the end of the video, which was a good point that was given by Bruce, the Moose, the one and only. He had talked about Rob's attorney asking questions, and he cross-examined. So because Rob's attorney did do cross-examination and did file some motions, because the bar to ineffective assistance of counsel is so low, it probably will not win on an appeal for ineffective assistance of counsel. Literally, the lawyer has to basically just do nothing. So he did something. So that might not actually work. So, I mean, Rob might just be stuck with this ruling that we are going to go over. All right. So let's get to that. I got some food in me. I took some medicine. All right, let's bring this up. So in part 1 that we just did, we watched the original ex parte motion for injunction against harassment against Hey Rob. We listened to that, and then unexpectedly, the video of the injunction against harassment where Owens testified and everything, that hearing we watched as well. That hearing is up on Justice for Clayton. Definitely go follow them if you're not. I was not following that one, and so I am now, but definitely go follow them. Schnitzel Ninja has the ex parte audio clip herself. Go follow her if you're not as well. And here is the motion. Let's make this bigger. All right. So we can see on February 23rd, 2026, it was filed on 2/26/2026, so 3 days later, in Owens v. Hey Rob, with attorneys Matthew Kelly and David Gingras. All right. So this is 4 pages. Under advisement ruling, which I don't know what under advisement ruling is. Maybe that's just how she's labeling it, because she said that she was going to take it under advisement. So this is the ruling that she said she was taking under advisement. This is the ruling for that. At the request of Hey Rob, an evidentiary hearing was conducted on February 20th, 2026, whereby defendant Hey Rob sought to quash the injunction against harassment issued on January 20th, 2026, in favor of plaintiff Laura Owens. Defendant Rob did not present any evidence during the hearing, though. Through counsel, he cross-examined plaintiff. Plaintiff was the only witness that testified. The parties stipulated the plaintiff was a litigant in a separate matter involving a person that appeared on The Bachelor, a television series. The parties agreed that the resolution in the case was not in plaintiff Owens' favor, and that a minute entry was issued by an assigned judge presiding over the proceeding. The minute entry contained findings that the judge was concerned plaintiff Owens presented false or misleading information to the court. Maybe you should have had her take under advisement that she is being charged for those things in that case, along with another case. Something Rob's counsel did not bring up. As a result of defendant foregoing the presentation of evidence, it is uncontested that defendant controls a YouTube channel that contains a catalog of approximately 1,300 or so videos that focus on plaintiff Owens. Defendant created 300 to 400 of the videos. It is also uncontested that defendant made the statements that were presented by a video at the hearing. While defense counsel asserted that portions of the videos played lacked context, the defense did not provide further context, which when we were watching that, I told y'all that context was needed. And it was not presented to the judge. So the judge doesn't have anything to counteract that argument. There is no doubt that free speech is protected under Arizona and United States constitutions. Defendant argues his conduct is protected in full, but Arizona courts have acknowledged that speech consisting of epithets or abuse of a person is not communication or information that is constitutionally protected. Let's look up what that word means, because that's a new one. Epithets. Okay. A descriptive word, phrase, or nickname used to characterize a person, place, or thing, often emphasized a specific quality. It's also a word used as a term of abuse. Okay. All right. See State v. Brown, appellate court of an Arizona case in 2004, quoting Cantwell v. Connecticut, a U.S. case from 1940. But the protection of citizens from harassment, a legitimate and laudable goal, is not incompatible with protection and exercise of free speech, especially with common sense interpretation of statute. LaFaro v. Cahill, 2002. Arizona revised status ARS 12-1809-T1A defines harassment as a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct in fact seriously alarms, annoys, or harasses the person and serves no legitimate purpose. Okay, so if you remember, Gingras would play a clip and then just one second. Okay. I don't want y'all hearing my daughter's conversation that she's having, but okay. Gingras would play a clip and then he would ask Laura, did that alarm, annoy, or harass you? And he also asked, he played several different things and said, the 400 videos, but there were at least 2 or more, right? because it needs to be at least 2 or more. It needs to be a series of acts, not just a one-time thing. While the court appropriately takes individuals' First Amendment protections very seriously, this court finds that the circumstances presented in this case, in totality, are harassment. The evidence presented is the defendant maintains a YouTube channel containing or cataloging around 1,300 videos about plaintiff. Defendant has approximately 1,200 subscribers to his YouTube channel. He has more subscribers than I do. Good for him. However, based on the testimony presented by plaintiff, the videos are accessible to anyone on the internet, not just those that subscribe to the channel. Okay. Without repeating the specific language used, it is difficult to convey the vulgarity of the language used by the defendant in the recorded videos. He refers directly to plaintiff as though he is addressing her specifically in some of the videos, while he uses obscene slurs to describe her, sometimes angrily ending with a rant with "F you," censored for this ruling. Defendant goes beyond verbal tirades to threaten to strike plaintiff through a phone, through a camera, or however he can get to the plaintiff. This is where he should have stopped at, "I want to bitch slap her through the phone." Not say that last part, "or any way he can get to her." And online, when you are speaking to people, you have to parse the way you say things. You can't just go off on a full rant without thinking about things that you're saying, unfortunately. Just like you can't, well, I mean, you can. It just could have consequences. Just like in church, you're not going to go off like that, usually in front of your congregation or your pastor or preacher or whoever. Um, you're not usually going to do that at your job either, unless people are quitting or getting fired and recording it for a TikTok. Most people don't do that because if you did these things, they would have consequences. All right. Defendant goes beyond the verbal tirades. All right. Another step beyond simple online statements is that in one video, defendant encouraged his viewers to impersonate plaintiff in order to find out whether the plaintiff would be present at a particular horse show. I think there's more context that needed to be laid, but as the judge has stated here, there was no context put on and given for that. There was a little bit talked about why, based on reporting, this is why he did it. This is why it was very important for Rob's attorney and Rob to put on a defense in this type of case. Other videos involved imagining scenarios where defendant appears to fantasize about the sexual victimization of plaintiff. In one video, defendant describes his belief that should plaintiff go to prison, she'll be repeatedly sexually victimized and impregnated. In another, he indicates he is aware of plaintiff's out-of-state travel due to plaintiff's court proceeding. He suggests he could have purchased tickets near plaintiff's seat on the plane on which plaintiff is traveling, and then she would let him join the Mile High Club. That is one of the things that the attorney did not check off that I wrote down that needed to be addressed. The joke about being on an airplane with her. I don't think there were fantasies. I don't agree with the judge characterization there. All right. The above are examples of the evidence presented and not intended to be all-inclusive. The language used in the videos is often crude, sexual, and violent. The sheer number of videos related to plaintiff is a factor in that it demonstrates defendant has a specific and targeted interest in plaintiff. This intense focus alone might not cross the line into harassment if the conduct was only online commentary. However, in the videos presented, defendant refers to plaintiff's specific living arrangements, i.e., the type of housing in which plaintiff resides, to her appearance at a specific horse show, and to her hospitalization for medical treatment. He needed to address the house and why we know what the house looks like due to body cam footage, due to things being in filings, all of that kind of stuff. He discusses on multiple occasions attempting to seek plaintiff out when he believes he knows where plaintiff might be, whether a horse show, in court, or in the hospital. Defendant's behavior might be argued to be online bravado from a keyboard warrior, i.e., a person that makes abusive or aggressive posts from a computer rather than in person in public. However, defendant physically appears at all of the plaintiff's court hearings and has admitted to attending at least one horse show at which the plaintiff appeared. The volume of videos and the crude and sexual violent language and the angry and vulgar comments verbally directed at plaintiff are concerning. Defendant's encouragement to those listening to take steps to locate plaintiff, the fantasizing about the ways to see plaintiff in person, including intimate, and the imagining of sexual victimization for plaintiff are beyond what any reasonable person would consider reporting, as defendant argues. I don't think he fantasizes. I don't. I'm going to say this. Do not reach out to Laura Owens. Don't go try to find her. Don't make contact with her or anybody else involved in this case or any other case that I talk about. So don't do that. Don't send hateful things to her or her family. None of that. We don't need to do that. Defendant argues that LaFaro versus Cahill supports his position that his conduct is not directed at plaintiff, but the case is distinguishable from the instant case. First, LaFaro v. Cahill involved political speech, which this case does not. So he is saying that defendant's argument about LaFaro, so when Gingras was like, oh, LaFaro says this, he's saying, no, Gingras, you're wrong about that. So your citing is bullshit. All right. Second, LaFaro did not involve a volume of conduct or posts to the internet. LaFaro involved statements at an event at a library rather than events posted online, which are there to be watched and rewatched again and again. Posting in the ways the defendant has about plaintiff in a violent and sexual manner, the repetitive nature of his conduct, the defendant's practice of physically appearing at a location, i.e., court, when he knows plaintiff will be there, causes plaintiff to feel alarm per plaintiff's testimony and what the court interpreted as fear during plaintiff's testimony. No, that was her panicking, her panic disorder that she admitted to in the hearing. That's what that was. That's her panicking. That's not her fear. The court finds this to be reasonable given the language and the behavior of the defendant. The court is not persuaded by defendant's argument that his conduct has a legitimate purpose due to public interest in plaintiff's criminal and civil cases. An allegation that someone has committed a crime does not open that person up to being terrorized by others. If one post or curates a selection of 1,300 videos about another person, the poster must know that pushing that much content about a person out to the internet will likely one day come to the attention of the targeted person. Not when they're a tiny channel. No. Because we're kind of a blurb on the internet to people that have way bigger followings. 1,000 things, why great, yeah. But it's nothing. It is nothing. And I don't think that just because somebody makes a bunch of videos that they'll one day find it and it's a target. No. Because if that's the case, then anybody who covers a case about someone over a span of so many years, that's just ridiculous. In fact, it appears that thought has crossed defendant's mind. As noted before, he directs comments at plaintiff though he is speaking to her, referring to her as you in more than one of the videos presented as evidence. For the reasons listed above, defendant's motion to quash the injunction against harassment filed February 6, 2026 is denied. It is further ordered denying plaintiff's oral request that defendant be forbidden from appearing at plaintiff's court hearings to observe the proceedings. It is further ordered, rather than entirely excluding defendant from appearing to observe plaintiff's court hearing, that the defendant shall stay at least 10 yards away from the plaintiff if he chooses to attend plaintiff's court hearings. Plaintiff may submit an affidavit regarding plaintiff's reasonable attorney's fees and cost. Issued and filed is the hearing ordered. Let's see. So he's going to need to sit at the back of the courtroom, basically, if he goes to court, if she's there. I can see her calling the cops on him during a court proceeding for sure. But that is her order. And while I don't like it, after seeing the hearing, I understand it more. I will be interested to see what Echoes says about that. All right. So, removing that. Also, don't forget to like and subscribe and comment down below. Now, let's see here. Gingras does submit an affidavit in support of plaintiff's motion for fees and costs. He talks about blah, 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 practicing these things. I went to this thing. I went to these schools, 25 years, worked for a judge, don't really care and see what that has to do. I also work as a volunteer for the bar of heirs. Okay, I don't know why we need your life story. Apparently, he sued Maricopa County and Maricopa County, or after they sued somebody. What? In 2022, I served as co-counsel in a federal lawsuit filed against Maricopa County, which accused the county of violating First Amendment rights of a conservative reporter. In the case, the county refused to grant press credentials to a reporter solely on the basis of his conservative reporting, did not qualify him as a real journalist. After we sued, here's the article. What does this have to do with any of this shit? I provided legal services. My standard hourly rate is $3.95 an hour. However, based on my knowledge and experience, This rate is extremely low, especially for experienced First Amendment. For example, my co-counsel in that was Mr. Randazza. I would like to know what Randazza's opinion of this particular thing would be. All right, attached here 2, Exhibit B is a timesheet reflected time spent on this matter. According to my records, I spent a total of 23.8 hours on this matter. Applying a reasonable hourly rate of $400, this results in $9,520 in attorney's fees. In addition to those fees, an additional $76.70 in cost incurred including electronic filing fees charged by the court. So basically total $9,600. Let's see. Given those factors, in the light of my obligation to only charge reasonable fee, factors of ER 1.5, I believe it is appropriate to apply a small downward adjustment of $1,000 to actual time spent. After applying this adjustment, I have determined that reasonable award of costs and fees for this matter is $8,476.70, declares under penalty of perjury. I don't know why we needed all that backstory shit. And that was his affidavit. This is just the motion. He talks about the rules regarding merits. Owens, a couple of points warrant attention. First was explained by Owens' brief. Accused Miss Owens of fabricating parts of her claim. This is a serious allegation. Yes, he did fabricate. She did fabricate things. And based on her original filing when she said these things were in this video. So, in his opinion, she mischaracterized and outright fabricated things. Based on the amended one that y'all submitted in court, no, that would be wrong. Talks about, the mistakes and all of that. Merits, explain the clear mistaken. To avoid responsibility. All right. Next question, in whether such an award would pose an extreme hardship. Reason 1 is that Ms. Owens obtained the initial IAH and he started crowdfunding, for his attorney. Because he has to pay his attorney as well. And as if this case did not already have enough strange facts, we are left with this tidbit according to the press release issued by Casino Arizona in 2021 that Hayrob was fortunate enough to win more than $250,000 playing 3-card poker. Okay, so a little over $252,000. Okay. Well, congrats on that. Given these facts, it is hard to imagine a case more deserving of a fee award than this one. He goes on to say that Rob, terrorized and attacked a young woman with videos containing vulgar language and disturbing things that the court didn't say. He did this on monetized YouTube channel. You need to understand what monetization is. So while seeking donations from crowdfunding campaign, if the facts don't justify full awards and fees. And then he breaks down pre-hearing, briefing, investigating, research, hearing, preparation, presentation, fee application, and then the cost. Signed, Gingras. $8,476.70. So those are those things. Dang it. Let me see here. Final order. All right, let me go to. All right. It's funny he has a password protected blog right now. Remember how I said I was leaving Arizona? Well, I have some good news and some bad news about this. Obviously, which thing you believe. Ooh. Ooh, we might get to that in a minute. Okay. I think I might actually, I'll address that in a different video. Okay. So, Gingras talks about, he does this for pro bono, but he thinks that Rob should have to pay his attorney fees. We'll see what the judge says about that. And Rob's lawyer needs to file a objection to fees and motions, but all right. Make sure I have this right. Okay. So he puts the under advisement rule. You can read the ruling for yourself. I really don't need to add much to what the judge said. Obviously, she got it completely. Thank God. What I want to add is this. If anyone has fought to protect the First Amendment, it is me. I spent years defending two websites that were broadly hated, The Dirty and The Ripoff Report. Between 2007 and 2019, The Dirty was sued 42 times. I defended every one of those cases. In doing so, I argued in most instances, the First Amendment protects my client right to say rude, nasty things, and I won every single contested case. Great. I won a case where my client posted nudes of a young Fox News reporter with the nudity redacted but still implied. I won a case where my client posted insulting comments about a woman saying he didn't want to have sex with her because it looks like she just had a baby. That's the dirty world. I won a case after case. I sang the praises of the First Amendment. Judges agreed with me all across the country. I made bags of money. I was respected as a First Amendment expert. Okay. But along the way, I also had to look into the faces of people who were seriously hurt by speech. I sat through 2 separate week-long jury trials in federal court in Kentucky, listening to a very bright young woman who was literally a convicted felon talk about how her life was destroyed by comments posted on my client's website. I lost the second trial, but won a massive victory on appeal. After that win, my client and I flew to Vegas and got wasted, celebrating in a strip club. We felt like kings. My client boasted that he personally saved the internet, even though I did all the work. Okay, why do you need to add that in there? Along the way, over 15 plus years of nonstop winning, I eventually realized something. Winning isn't all that matters. Sometimes there's a higher purpose. Sometimes discretion is the better part of valor. Really? Because the way you talk about people doesn't seem like you give a shit. The First Amendment does not protect speech, but there's a limit. At some point, you have to accept the fact that, yes, you do have the right to express your views. No question. but at some point that freedom ends. You can't joke about taking a bomb on an airplane. You can't joke about wanting to kill the president. At some point, you can't say things that repeatedly terrorize another person. That's not free expression, it's criminal harassment. And even if you could harass or terrorize someone, you shouldn't. And he says, "Look, I have a big mouth. I have talked as much shit as anyone, probably more. I like the fact I live in a country that allows freedom of speech. Bearing in mind, the Arizona bar wants to pull my license based on things I've said. So clearly, not everyone believes speech is always free. My point is this: JFC's righteous march to seek justice and breadsticks, people have forgotten an important point. We are all human beings. Laura is a human being. She made mistakes. What mistakes? Because she has admitted to zero. She needs to admit to her mistakes. But she has taken zero accountability. We all have. And yes, mistakes warrant criticism, sometimes a lot of criticism, but there is a line, there is a limit, and there are consequences when you cross that line. Expressing cruel, vile, hateful, violent comments over and over and over and over and over directed towards a single person who is already struggling. I'm sorry, guys, but as a guy who loves the First Amendment and has fought tirelessly to protect it, at some point, hate goes too far. You have a right to speak. You do not have the right to torture. You do not have the right to strike fear into another person. You don't. So, all those things that you said about Lauren, she's a person that has already been struggling, but you continue to jab at her. Things that you said to Dave Neal, things that you've said about Megan Fox, Tug, Legal Vices, God rest his soul, lies that you've put out about me. So, sorry, you're a hypocrite. Be nice to Laura, but you can do whatever the fuck you want. In this case, it went way too far. And as a result, a judge just agreed Laura was credible and the speech in question was completely out of bounds, even in a country that prioritizes speech. Think about it. I'm not saying that the judge didn't agree with Laura as to certain things, but the judge's hands were kind of tied because there wasn't a defense. Had there been a defense put on, maybe this wouldn't have happened. But Laura got lucky in that, I guess. Next step's pretty simple. First, the court awarded fees, or at least allowed me to apply for them. Right. They allowed you to apply for them. So that's nice. $6.50 an hour, maybe more. He didn't ask for that. So he's just boasting here. Second, this order could be appealed, but it won't be. Why not? Because as practical matters, you cannot appeal factual rulings. You can only appeal legal mistakes, which is true. This ruling was based on the facts, not the law. Although the judge got the law 100% right, there is no legal error to appeal on. Does this spell doom for JFC as a whole? Surely not. But it should serve as a wake-up call to anyone who thinks the internet is a lawless cesspool where you can spread endless hate without consequences. Nobody here thinks it's a lawless cesspool. We know that there are bounds and limits and things that we are and are not able to do. And just by saying that one person did a thing doesn't mean that everybody is doing that same thing. You are making it seem like because one person has done something that the whole group does this shit. And that's just not how it is. And I if she runs across my videos, fine. She watches them, whatever. I think I am pretty fair on things. I don't like her. I have called her names. I have called you names. I don't think I have stepped out of bounds in anything that I have done. And if you don't believe me, you're welcome to test me. I'll gladly come educate you, and you will almost certainly lose as long as the case is heard by a judge who is not trying to impress her dad sitting in the next room. Here he goes, making jabs at Judge Mata again. So sorry. So keep talking about this case. Keep talking about me. Keep the breadsticks coming. But while you're talking, remember something. Kicking someone else, especially when they're down, isn't nice, and you may eventually get kicked in return. I don't give a shit that she is down. She did this to herself, and she has taken no accountability. So if she wants to quit being kicked while she's down, maybe she should take some accountability. Try to have a heart. Try to show some mercy and grace. Try to realize that when you spread hate, your words aren't just words. They are weapons that can hurt people, and sometimes you just end up hurting yourself. And then, all right. So that is his blog post, which um it is what it is. I don't agree with everything he says. I think a lot of it is very hypocritical, but that's his thoughts and opinions, and he can have them. All right. The next thing that I wanted to talk about was the Love Trapped podcast. The Love Trapped podcast has put its first 2 episodes out, and I don't know if we're going to get 2 episodes every week or we just got 2 episodes up front, and then we will get the rest of the 8 in 8-week increments. So we shall see. I don't know how Stephanie Young, who is the person doing this podcast, is going to get everything in these 10 episodes. I I don't know how she's gonna do it. The first 2 were just about, like, Clayton and kinda getting to just the beginning of this, and then we're supposed to cram everything else in. I guess because Laura doesn't have her side fully in there because she has chosen not to comment, which is probably best for her while she's under criminal indictment. Um, I do like that it is kind of somewhat neutral. It's just telling the story. They made Laura look like a decent person as far as who she is. She likes the animals, her family is close knit, all that. But they do go into what some of the things that may trigger Laura to act the way she does when it comes to men, that she maybe doesn't have self love. I don't think she loves herself. I think she doubts that even her family loves her. I think she worries about not being good enough, which sucks. I mean, I think a lot of us can relate to that, but therapy and counseling and stuff like that, you don't go ruin people's lives because of it. Uh and while some people think that, some of this can be triggered because she doesn't feel like she's good enough or that maybe her sister's pregnancy triggered this. The thing is maybe it triggered one incident, right? But the fact that this playbook has been played over 10 years, and there was Greg and then there was Clayton. I mean, she had a gap that we know of between Mike and Greg. I don't know about anybody else in the middle, but she did this shit to Greg and to Clayton. So what triggered it here to do it to 2 guys? Could understand maybe 1, but doing it to 2? Really? I don't think that can be explained. But it's a very good listen, learning new things, that the text messages that she sent to Clayton early on are more identical to Greg and Mike's, plan B conversations and things like that than we thought previously, or at least Greg's case. I don't know if she discussed plan B with Mike. Um, but it's very interesting and I like getting to hear Clayton kind of tell his story. Um, I don't like the way that Clayton's mental health was at the beginning of everything because Clayton hasn't had a break. Um, and he's still dealing with this, but I'm hoping that this community and everybody that supports him in this is the start of his next new chapter and things finally going good for him and right for him in, his adult life. And that his 30s are going to be way better than his 20s. So, um, let me know what y'all think about all of this in the comments. Yeah. She's going to be they're going to be losing their house. Don't know where they're going to go. She can't leave Arizona right now without permission. So she doesn't have permission to leave the state of Arizona and move somewhere else. Will they stay at Gingris's house or will she at least stay at Gingris's house? Who knows? But doesn't sound like from what I just read in a blog, which I will do a video about later, um, doesn't sound like Gingras is gonna be in Arizona for very long either. So we shall see where everything goes. But thank y'all for coming and watching and sticking with me through this. I am going to go and let's see here. Mm. Dang it. What was I going to do? Customization. Okay. I'm going to redirect over to Echoes. Well, possibly. Okay, I cannot redirect to Echo's stream for some reason. He doesn't have that turned on or something. But if you go over to Echoes, then put your little duckies in the chat and let him know. I'm going to be going over there as well. And I will see y'all later. Have a good evening and a good rest of the weekend.